Hello folks, welcome back. Please let us know the quality of the audio. Just let us know the quality of the audio as we are doing our possible best. What we will tell you is the jurors have arrived. That is for sure. The jurors have arrived, and the defendants and prosecution currently in the courtroom. The jurors are making their way inside the courtroom. Once they make their way in the courtroom, we will then continue to bring this live podcast. But we cannot under no condition show the jurors in this case. That is totally against what we signed up to do here. So what we can tell you is the jurors are standing in a line. They will be making their way into the courtroom. That's the reason we've come a distance to allow for their identities to be protected, the security and the sanctity of the work they do. The jurors making their way into the court, I can tell you that for sure. The court is all standing. Everybody in the court standing as the jurors make their way to their bench. So once the jurors are seated, then the doors of the court, because both doors were opened, and you can see the police here also making the perimeter secure for these jurors as they make their way. So now the jurors have the National Police Support Unit. In the courtroom as we speak. There's no space in the courtroom as we speak. So please let us know the quality of the audio. Please let us know the quality of the audio. This is the final arguments, or if you want to call it closing arguments, in this particular landmark case. There is no space in the courtroom. Criminal Court C is packed to capacity. The presiding judge has now entered the courtroom to take his seat, and we will be bringing you all of what is happening. Just let us know the quality of the audio. Please tell us the audio quality. Just let us know the audio quality, and I will be bringing you updates from within the court. I'll be bringing you updates from within the court. Well, if you're just joining us, my name is Diamond Slanger, and this is a Spoon TV Live coming to you before Criminal Court C, the case involving former Finance Minister Samuel Tweah, former Acting Justice Minister Tweah, and other co-defendants. This case is currently before the Judge Roosevelt Willie. So he was appointed to this trial by my girlfriend for me, chief. I don't work for you. Won't you ask me? Yeah, bring it now. Ask for my permission. Bring it. So we'll try to recollect our notes. Once we do that, we'll get back before the camera, but we cannot show you the inside of the courtroom. We cannot do that because that is against what we signed up for. That is against what we signed up for. We cannot show you the inside of the courtroom. So Liberians are equally vested in this particular case.
The 19 and the 21 of 2023, in the course according to the total amount that was taken out, the government of 8
So you can see the police very present here. I can tell you for sure. So now let's go back to what history this case is going to make in Liberia. What history will this case make in Liberia? This trial is going to make history in three major ways. One, this is the first major test of the National Security Reform and Intelligence Act, the NSRI. This is the first major case to test the National Security Reform and Intelligence Act, the NSRI Act, in a corruption case. This is the first history that this case is making. Never before in Liberia has the court taken, or has the court been asked to decide whether the National Security Authority can shield senior officials from prosecution of financial crimes. So remember, when all of this started, the pre-trial, the motions, all of these, the co-defendants were arguing that they were protected by immunity, that they acted in the national security interest of the country, and hence they couldn't be tried. Now, this is the first record that this case is breaking. So the first major test for the National Security Reform and Intelligence Act to be tested in a corruption case. Never before, has a Liberian court been asked to decide whether National Security Authority can shield senior officials from prosecution for financial crimes. We move to the second historical point in this particular case. This case will determine as well whether national security, the tag national security, can justify moving public funds without documentation. We have heard these arguments prior to this case, and even during the course of this case, that look, the actors acted in the interest of national security. So this case is going to determine whether national security, the tag of national security, can justify just moving public funds without documentation. It's also going to determine whether the president's security powers override public finance laws. This case is also going to determine whether officials can claim immunity or financial decisions were made under security operations. That has been the defense's main point, that their clients acted under the National Security Act. They acted with impunity. They cannot show where the monies were disbursed to because of the tag national security. And so this is what is going to shape how future government handles classified spending. Remember, the spending in this case classified as national security. The disbursements have been argued. Samuel Tweah, when he took the stance, said that, look, you cannot prove that I benefited personally from the funds that were used. You cannot show any paper trail. When the former defense minister, the former chief of staff, took the stance, they also said they cannot account for where that money was disbursed to them or not. They have no knowledge of that whatsoever. So this is really a very big and pivotal case. It's not just for what transpires today in the courtroom, but it's what it is going to set in terms of a precedence. So this is also the first time for a former finance minister to face full corruption trial over internal government transfers. So Samuel D. Tweah is the first finance minister in Liberia to face full corruption trial over internal government transfers. Liberia has prosecuted ministers before, it's true, but not a finance minister for the following: A, transfers between government accounts; B, without proof of personal enrichment; C, based solely on procedure and accountability violations. So we want to see if we can go back into the courtroom where we have our correspondents seated to bring you updates as to what's happening in the courtroom. So the fellow who was rushed out by the police officers on the account of the judge, that fellow has been sentenced to 30 days imprisonment. That is what we have been told from within the court. I personally saw the judge leave his seat, his bench, come all the way to the Liberia National Police headquarters and said, take him to jail. What we've been told is that that particular fellow has been sentenced to 30-day imprisonment for contempt of court. So that is what we can tell you as well. He's been committed, to 30 days imprisonment. So we'll be bringing you more updates. Keep letting us know the quality of the sound. So this is a historic trial in Liberia. This is the first time for a finance minister to be brought to full trial for internal government funds. So Samuel Tweah and other co-defendants are in the court. The former finance minister is wearing a blue business suit with a pinkish-like tie under. The former Solicitor General and acting Justice Minister at the time, Tweah, is wearing a predominant blue African suit with pink over the shoulder. The former controller is also wearing a gray-like business suit, and we didn't see the other co-defendants. So we'll be bringing you more updates. Let's see if we can go back into the courtroom as well as bring you more. So this is Norris Tweah, the brother of the former finance minister. He has been asked to return because the courtroom is crowded, as we said, it's packed to capacity, and there is no new entry being allowed in the courtroom. So this case is going to explain the legal definition of economic sabotage and misuse of public funds. This is also the first corruption case where the Supreme Court intervened mid-trial on a writ of prohibition. Remember, Samuel Tweah and other co-defendants, argued and appealed the ruling of the circuit judge on whether or not they qualified to be, put under the bracket of presidential immunity. In mid-trial, they took a petition, a writ to the court. The Supreme Court ruled. So this case has got a lot of historical markers as well. So the final ruling of this case is going to be a constitutional precedent. Future corruption cases involving national security will definitely cite this particular case. That is what we can tell you for sure. What the verdict will be, we cannot determine that as of the moment, but the court is in session as we speak. We'll also be going to what punishment under the Liberian law is appropriated to these charges. But first, we'll read out what the charges are. Charge number 1, economic sabotage. The Penal Law of Liberia, section 15.80. It is punishable by, if you found guilty of economic sabotage, it's punishable by up to 10 years imprisonment, fines, restitution of the amount said to have been misapplied. Those are the punishments for economic sabotage. Up to 10 years imprisonment, fines, restitution of the amount misapplied. Economic sabotage also includes misuse of public funds, unauthorized expenditures, and illegal transfers. The second count, theft or misapplication of property, Penal Law 15.51 and 15.56. If convicted, you face up to 10 years of imprisonment and mandatory restitution. That is for theft or misapplication of property. The next count, even if, and under this theft of property or misapplication of property, even if no personal benefit is proven, misapplication of public funds is still a crime. So remember, the defense has been saying that, look, our clients did not benefit personally from these funds. You cannot from the misapplied or the alleged misapplied funds. But under the Penal Law of Liberia, sections 15.51 and 15.56, which deals with theft or misapplication of property, if convicted, a convict faces up to 10 years imprisonment, mandatory restitution, even if no. The third count is money laundering, the Anti-Money Laundering Act. If the prosecution believes that the funds were used to conceal their purpose, the penalties include up to 20 years imprisonment, asset forfeiture, heavy fines. But without tracing the funds to a private or illicit destination, the charge becomes hard to sustain. D. Criminal conspiracy. Penal Law Law of Liberia, Section 10.4, is punishable by up to 5 years imprisonment or the same penalty as the underlying offense. So folks, you have listened to the various charges and the punishments as prescribed by the penal law of Liberia. So let us know again the quality of the audio, the audio quality is good. Please let us know by just leaving a comment. The time here in Liberia is 9 minutes up to 4 p.m. Official proceedings here began at 11 a.m. We were told 10 to 11 a.m. We have given you the background of this case. We've given you the prescribed or ascribed punishments according to the penal law of Liberia. So please let us know the quality of the audio. If you're watching us, just let us know the quality of the audio. Check your devices, please, and let us know the quality of the audio. What we can say is, earlier on, the fellow who was being rushed out by the police, that fellow has been committed to 30 days of imprisonment by the judge here. So that is what we can tell you is transpiring. So each party has been given 1 hour 30 minutes each for final arguments. Do not stop the politics. Again, we are facing some serious challenges with the microphone here. Just keep letting us know the quality of the audio. We are facing some challenges with the audio, but we'll keep doing our best to make sure that the audio is good. So what breaking news from in the court is the final argument is on the way. Each party, that is the prosecution and defense, have been given 1 hour 30 minutes to argue before the court. 1 hour 30 minutes for their final arguments. So the prosecution is up first, and let's now go into what angle the prosecution is going to work. What the prosecution needs to do now, what all they have done in 4 months, 1 week. Remember, this trial has gone on for 4 months and 1 week. So the prosecution needs to prove, needs to convince the jurors, needs to, beyond all reasonable doubt, one, to convict. The prosecution needs to do the following. They must show the following. One, that the transfers violated the public financial management law of Liberia. The prosecution must prove beyond all reasonable doubt that these transfers violated the public financial management laws of Liberia, the PFM law. The prosecution must prove beyond a reasonable doubt that one, there was no legislative appropriation. They should prove that no approved budget line, was in the budget for the funds that were removed. They should prove beyond all reasonable doubt that there were no proper documentation during the course of this trial, whether or not the prosecution have been able to do such. The prosecution must also be able to show that the NSR Act does not override accountability. Remember, the defendants were pushing to the National Security and Reform Intelligence Act. They were saying that, look, we were covered by this. The prosecution must prove again that the NSR Act does not override accountability. That even if you say national security, there should be accountability for public funds. So the prosecution must prove that before the open court and convince these jurors on the following. They must also convince the jury that national security spendings still requires accounting. That even if you say we did this for national security, you should be able to account for whatever funds that were given. The prosecution must also prove that immunity does not apply to financial misconduct. That even if you are covered by immunity, you are still liable to behave in a way that is considered best practice. That national security or immunity does not apply to financial misconduct. These are the arguments that the prosecution must have made over 4 months and 1 week and will summarize within their final arguments. As I said earlier, each party has been given 1 hour, 30 minutes to produce and make their final arguments as well. The prosecution must also prove the following: that the defendants acted knowingly and intentionally. And the hardest part for the prosecution is for them to prove intent. The prosecution must show that the defendants had the intent to bypass the law. The prosecution must show that the defendants had the intent to conceal. The prosecution must show beyond a reasonable doubt that the defendants had the intent to misapply the funds as well. So all of this, they'll still have to do this and show that the funds were misapplied and unaccounted for, even without personal enrichment, or the misapplication is just enough in this particular case. So folks, we just told you what the prosecution needs to do. So in their final argument, they must summarize all of these points: that look, all of the defendants had the intent to bypass the law. All of the defendants had the intent to conceal. All of the defendants had the intent to misapply the funds. The prosecution must also show that the misapplied funds, were unaccounted for as well. The prosecution, in their final argument, must also show that, look, they must convince the jury that, look, even though there is the NSRR Act, but still, it doesn't in no way shield these defendants from financial misconduct. That is what they'll have to do. Now we've heard what the prosecution needs to do in their final argument. The final argument is ongoing now. I will pause for a minute and go straight back into the courtroom to bring you up to speed with what is currently happening there in Criminal Court C. The courtroom is jam-packed. Even the air is thick in there. The tense, the level of uncertainty, the futures of not just those co-defendants, but the prosecution also is at stake. The government has gone all out in this case, this historic case. First finance minister to be put before a full trial about internal spendings and transfers within the government of Liberia. This particular trial is going to in a long way be a precedent in if or not national security covers misappropriation and misapplication of funds. Whether government officials can claim we acted in national security interest and show no accountability whatsoever. So let's go back into the courtroom now. Let's go back into the courtroom. So Councillor Jerry Garawolo, Councillor Jerry Garawolo is on the floor right now. He's the one speaking. So he's charging the jury. He's telling them that, look, they've informed them that they were going to produce witness, the checks produced, the linkages, and they did that. They brought people from the Central Bank of Liberia during the trial. They talk about bank statement, and yes, they presented it. That Cooper said he got the money, but can't remember those officers he gave the money to. He said the trial of the defendants is not a witch hunt, but rather to have people taking responsibility for what they do. Just on cue, as what I said earlier, that the defense needs to do in their final arguments, what they've been trying to do since this trial began. So we'll bring you more updates from the court as the prosecution is still on the floor. The prosecution is first up in their final arguments before jurors. We witnessed the jurors entering the courtroom, and we want to go back into the courtroom and bring you more updates. Now, he said the jury should hold all of the defendants guilty for not being able to account for the money. If they received the money, if the paper trail showed that, yes, the money left the Ministry of Finance, it was transferred into the FIA's account, they should be held accountable. They should be found guilty for not being able to account for the money. Remember, Samuel Tweah's big defense was the prosecution could not in any way show that personal enrichment, he benefited from those funds. The prosecution is saying in their final arguments, as I said, even if personal enrichment cannot be proven, the fact that they cannot account for said monies, they should be found guilty. So the former Minister of National Defense said he had no idea about the money. That's Major General Daniel Zianga. He was brought in this very court to testify, and he said he has no idea as to the whereabouts of the money. So the prosecution is using all of those points from its witnesses and all of the evidence they adduced to call on the jurors to find the co-defendants guilty. We're still on the prosecution. While they're making their case, let's go back now to what the defense needs to do in their final argument. The paramount responsibility of any defense team or defense attorney is to sow the seed of reasonable doubt. That the state, beyond all reasonable doubt, convince the jurors. As a defense attorney or a defense lawyer, you are to create those reasonable doubts. Now, what the defense must do to avoid all of this, that is what I want to bring to you, and then we'll tell you what the jurors will be looking at in making their defense. So what the defense needs to do in this case, one, the only thing the defense needs to do is to create reasonable doubt. That's all. That's the only thing they need to do. To say, look, the state is accusing our clients of misappropriations, misapplication of entrusted property and all of these things, but the state cannot prove beyond a reasonable doubt how did our clients misapply these funds. How did they benefit as personal enrichment and all of that? So this is what the defense needs to do. One, the defense needs to argue that the fund stays within government accounts. That their clients did not take the money out and use them for their personal enrichment. The defense needs to tell the jurors, remind the jurors that, look, there's no personal benefit. How can you say our clients misapplied around 6.2 million United States dollars and the state cannot prove if there were personal benefits, even though the law states that, yes, even if you cannot prove personal benefits, misapplication can also be proven. But the defense can stand up and say, look, the state cannot, under no circumstance, the state has not proven beyond a reasonable doubt that our clients benefited from these monies. The defense can also argue that, look, national security required rapid action. So we got the money, yes, and we applied the money because the monies were needed for national security actions and it needs rapid action. So how can we now come and say, oh, the monies were not used appropriately? The defense can use that to create doubt in the minds of the jurors. The defense will also have to argue that, look, documentation exists, but it's classified. So because it's classified documents, we cannot produce. The state cannot unearth national security, operations because we want to get a conviction. So because of that, that's the reason you cannot see where the monies went to and which agencies and all of those things. So that's one of the things the defense could look into and use as creating reasonable doubt in the minds of the jurors. The defense can also argue that, look, the LSCC that drew up this indictment, the LSCC, failed to trace the money. And the LSCC's investigation was incomplete. So how can you use an incomplete investigative report to convict these astute citizens, according to defense lawyers? That's one of the things they need to do to be able to create reasonable doubt in the minds of the jurors. That, look, the LSCC said they did their investigations, but they couldn't find where the monies went to. So they failed to trace the money. And if the money is untraceable, how come you said our clients benefited from that as well? Reasonable doubt. And lastly, the defense can argue that there is no witness to prove wrongdoing. So if you cannot prove wrongdoing, how can you convict our clients of wrongdoing? And if they're able to sow the doubts, reasonable doubts in the minds of jurors, deliberation will prove that. So we've told you what the prosecution needs to do and what the defense needs to do. We'll go back to the history of this case, but let's go into the courtroom now for more updates. I'll take a short water break, and once I get back, I'll bring you more updates from within Criminal Court C. My name is Diamond Slanger. It's a lengthy tax here. Take a short water break, and I will bring you all of what is happening in the courtroom. All right, folks, welcome back. We will be bringing you updates from within the court. What we can tell you is Councillor Jerry Garawolo is on the floor. He is doing the closing arguments, the final arguments for the prosecution, and just a recap of what he has told open court. That one, remember, each party has been given 1 hour 30 minutes to argue final arguments. Each party 1 hour 30 minutes, and the counselor for the prosecution is telling open court and the jurors that look, he's charging the jury, saying that they informed them at the beginning of this trial that they were going to produce witnesses, checks, productions, linkages, and they did all of that. According to him, they brought people from the Central Bank of Liberia, and during the trial, they talked about bank statements, and he said that yes, they produced bank statements. He also said that Cooper said that they got the money, but cannot remember the officer he gave the money to. He said that the trial of the defendants is not a witch hunt, but rather to have people taking responsibility for what they do. He also said and asked the jury to hold all of the defendants guilty. They should find them guilty for not being able to account for the money. He said that the former Minister of National Defense, Major General Daniel Zianga, said that he had no ideas about the money. He also said that the former Chief of Staff, now head of the National Security Agency, Major General Prince C. Johnson, said that he also had no knowledge about the money. He also said that they said it's the first time for a direct transaction to go that way, and that there must be proper documentation for monies to be dispersed. So he's reminding the jurors, he's reminding the jury about what they set out to do and what they've been able to, according to him, beyond a reasonable doubt, prove that these co-defendants should be found guilty of all of the charges leveled against them. 1 hour 30 minutes to each team, prosecution and defense. The prosecution is first up, and these are live happenings from within the court. We cannot take the camera and the microphone in the court. That is not allowed unless it's approved by the judge at the beginning of the trial by all parties. But that wasn't done, so we can only bring you updates from the court in this way. Is Samuel Tweah in court? Yes, he is. Other co-defendants in court? Yes, they are. Prosecution, the Solicitor General is. Arthur Johnson, lead defense counsel is. Witnesses, I can tell you for sure, the courtroom is packed to capacity. Extra benches were taken in. Early courtroom drama, we saw one individual being whisked out of court, bundled up by several police officers. From the CDC, Gayazon Abba Davis has been committed to 30 days imprisonment by the presiding judge for contempt of court. So we will be bringing you updates, more updates. We've told you what the prosecution needs to do, what the defense needs to do in their final argument, what they should have done in the 4 months, 1 week of this trial, and what they need to hammer home with the jurors, both teams. Prosecution needs to hammer home the fact that they've proven beyond a reasonable doubt that all of these co-defendants should be found guilty of those charges. Defense will have to prove that, look, there's a lot of reasonable doubt and these charges our clients cannot be held liable for, charges that has got a lot of doubts riddled or in between. So now let's go to what the jurors will be charged to do, what the jurors will be looking at, and what produces a conviction, what the jurors need to do to produce a conviction that is a guilty verdict on all counts. So in Liberia, we use the 12-person jury in criminal courts. So this is the same thing that is happening in criminal court C. So the first thing is standard of proof. The prosecution must prove every element of each charge beyond a reasonable doubt. That is the standard of proof. For conviction, the jury must unanimously agree that 1. The defendants intentionally moved public funds. That's 1. The jury again must unanimously agree that the transfers were illegal under the public finance laws. The jurors again must prove that the defendants knew that the transfers were unauthorized. The jury again must unanimously agree that the funds were misapplied, misaccounted for, unaccounted for, or concealed, and that the defendants acted together to be able to convict them of conspiracy. So for conspiracy, you must prove beyond a reasonable doubt that all of these co-defendants acted together, they connived, and they had a conspiracy. So even if one of the elements is not proven beyond a reasonable doubt, the jury must acquit. So to get a full conviction on all of these charges, again, let me remind you what the jury will need to do beyond a reasonable doubt. They have to firstly establish what is known as a standard proof, that the prosecution proved beyond a reasonable doubt every element of each charge. For a conviction, the jury again must unanimously agree that 1. The defendants intentionally moved public funds. 2. The transfers were illegal under the public finance laws of Liberia. 3. The transfers were illegal, as I said, under the public finance laws, and the defendants knew the transfers were unauthorized, that the defendants misapplied the funds and the funds are unaccounted for or concealed. You can see folks are being turned away because there is no space. No space in the court. The sheriffs are implementing this for over an hour now. People have been turned away. But back to what the jury needs to do to have a full conviction on all charges, that the defendants acted together and they conspire. Even if one of these elements is not proven beyond a reasonable doubt, the jury must acquit on that particular charge. Now, what does the jury need to do to have a hung jury? What produces a hung jury? One, Liberia requires a unanimous verdict. 12-0 to convict, 12-0 to acquit. Unanimous. To have a hung jury, this occurs when even one juror disagrees. If the vote is 11-1, 10-2, 9-3, or split, or any split, you have a hung jury. Once the jury is deadlocked, it's a mistrial. Then the prosecution may then retry the case, offer a plea, or drop the charges. So this alone, my people, it gives enormous power to a single juror. That is why you must go beyond nails, teeth, and tongue to prove beyond a reasonable doubt these charges. And as I said, the defense only needs to plant the seed of doubt in the head of a single juror or more than one. So let's go to the courtroom again to see what's happening. The prosecution said the defendants cannot say where they attended the joint security meetings, who were those present, and what are the institutions that received the money. So again, the prosecution is reminding the jury that the defendants could not state in open court where they attended security meetings, who were those present in the meetings, and what are those institutions that received the money. According to the prosecution, the defendants have been able to tell anyone who received the money. They've been unable to say who received the money. More updates coming in. Keep watching Spoon TV Live from just before the main entrance of Criminal Court C, a landmark case. It's what is happening right now. And we will be providing you analysis as well as live updates from within the court. My name is Diamond Slanger. We have our correspondents in the courtroom. We are not allowed to enter the courtroom. So all we need to do is to bring you live updates from within the court. National security versus accountability. Who's covered by what, and whether or not immunity means public funds cannot be accounted for. Whether or not the state has been able to, beyond a reasonable doubt, convince 12 jurors plus 3 standby jurors that these co-defendants conspired, misapplied public funds, and committed economic sabotage. We will go back again to tell you what these charges mean under our laws in Liberia. Will the defendants be jailed today if they're found guilty? The answer is no. They will not be sent to jail even if they're found guilty by the jury today. There will be a sentencing ruling where the judge will ask them to come back for sentencing. Remember, they have the their bond is still covered by their bond. So they all have been out, not in jail during the entirety of this trial. So even if the jury convicts on all charges, they will not be sent or committed to jail today. They would have known their fate. And if the defendants are, again, this is analysis, it is not definite. We are analyzing from all angles. If these defendants are found guilty on all charges or some of the charges, they will not be sent to jail immediately. They will be allowed to leave with their lawyers, and a sentencing date will be announced. And on the sentencing date, before the judge sentences, the probation office from the Ministry of Justice will go in the community and do what is known as the pre-sentencing, the pre-sentencing formalities. They'll go out there, they will do reconnaissance on the individuals that have been found guilty, their records and all those things, and then they will make a submission to the judge, and the judge will then use that, to then hand down the sentence. We've told you the sentences associated with each of these charges. So let's go back in the courtroom for more updates. So the prosecution is reminding the jurors in its closing argument, in its final argument, that look, the former National Security Advisor Jefferson Camo said the entire 2023 he did not see Councillor Yanti Tweah. So the question again is, where did they attend national security meetings? Who were in those meetings? And where and whom did they appropriate those funds to? So the prosecution is reminding the jury again that Jefferson Camo said he did not see Councillor Yanti Tweah in the entire year of 2023. There is a pause in the court. I can hear the gavel being hit. 1 hour 30 minutes for the prosecution to make its final argument. 1 hour 30 minutes for the defense to also make its final argument. Then the jury will retire to its deliberation room. As to how long they'll remain in our room to come up with a verdict on each of these counts, we cannot speak to. But there will be a verdict, and a verdict will be delivered. So the first prosecution lawyer has rested. We've been informed that another prosecution lawyer will use the remainder of their time, 1 hour 30 minutes. They're calling for silence in court. They are calling for silence in court. Now, let's go back to a summary, an analysis of what the closing arguments from both prosecution and defense should entail. What must the prosecution argue? First, the prosecution must argue that the transfers were illegal under the Public Financial Management Law of Liberia, that there was no legislative appropriation, there was no approved budget line, no expenditure vouchers, no receipt from security agencies. And you listen to the first prosecution lawyer, he hammered home this point that the defendants cannot show whom did they give the money to. They cannot show because the former National Defense Minister said he is not aware of the funds. The former Chief of Staff of the Armed Forces said he also was not aware of the funds. So the prosecution is hammering home this point that no receipt from security agencies were shown or provided. The legal point of this is, under the PFM law, every public dollar must be traceable. Failure to account equals to misapplication even without a theft. The prosecution must also show that national security does not override accountability. the prosecution must argue in its closing statement, in its closing argument, that look, the NSRI Act requires accounting and auditing, that immunity doesn't apply, immunity only applies to lawful acts, and that security operations cannot be used as a blanket shield. The prosecution must hammer home these points to the jurors in its closing argument. The prosecution again must argue intent can be inferred from conduct. What does that mean? That even without personal enrichment, intent can be shown by the following: that one, bypassing normal procedures, moving unusually large sums of money quickly, failing to produce documentation, providing inconsistent explanations. Again, we witness from the first prosecution lawyer trying to hammer home these points, that look, the intent can be inferred from conduct, that the conduct of these defendants, even without personal enrichment, because that was the main defense of former Minister Samuel Tweah, that you cannot show and that I benefited from these monies. There were no personal enrichment from these monies. You cannot show that I benefited riches or anything else from these monies. But the prosecution can counter that in its closing argument and say, look, even without personal enrichment, the intent can be shown, that one, by bypassing normal procedures, that you conspire to misapply these funds. That's the reason you bypass normal procedures, that you moved unusually large sums quickly, to be able to get them out and use them for whatever benefits, that you fail to produce documentations because you don't have any documentation whatever, to show that these funds were used for the intended purpose, and that you all provided inconsistent explanations, and that shows, conflicting narratives. So we are waiting for more updates from the court. Spoon TV, 2 minutes to 12:30 midday. It's a very, very hot day in Liberia. Please keep leaving your comments and let us know. Councillor Arthur Johnson is on the floor, the lead defense lawyer. Councillor Arthur Johnson is now on the floor. We will be telling you all of what he's saying, but this is what the defense needs to push in their final argument. The defense needs to push, number one, that there was no personal enrichment, so therefore no crime. The defense must hammer this home by saying, look, no bank statement showing diversion. There is no bank statement to show whether or not these monies were diverted into individual accounts and for individual usage, that there were no private accounts, that there were no cash withdrawals, that there are no witnesses saying that the defendants benefited. The defense can also argue that all funds stayed within government accounts. They can argue that the transfers were internal, that the money were used for real security operations, and that the documentation exists, but these documentations are classified. The defense can also argue that national security required urgency. The defense can say, look, this was election period, it was volatile, and it was an emergency, and we needed to move with expediency. They have to say that, look, there were security threats that were real, and we needed to act accordingly. And the finance minister had a discretion that written approvals were not always possible in such times. So the defense can argue that as well. So let's see whether or not these are the lines that the defense is pushing. Let me see if I can go back to our correspondence in the court. So those were just lines that a defense attorney in this case should be pushing in their final argument. So we want to see if the defense is pushing that line. So he's saying that during the trial, the prosecution said they were going to give open statements. Let's see whether or not he is going to say if they produce those statements or not. This is a landmark case. Wherever you're watching us from, I'm hearing the PFM law is being cited in the court. He has said that the former finance minister did not have the authority to pay, and that the minister's source of authority is in the PFM law. So they're saying the prosecution had no authority to say Samuel Tweah did not have the authority. They're saying that the minister has the authority to pay in the budget and outside the law if there is an emergency. That is what the defense is saying. So speaking to the point that I made, that the defense can work the angle that it was an emergency, it was election year, it was volatile, and that classifies as an emergency. And during these times, funds can be moved with or without, documentation based on credible security threat. So that is what the defense is pushing. The defense lawyer, Councillor Arthur Johnson, just stating that the minister has the authority to pay in the budget and outside the law where there is an emergency. And he's further said that the prosecution did not rebut that Tweah source, that his backing is the PFM law of Liberia. So the defense is pushing that the transfers, the authorization, and everything were within line with the PFM law. So I can hear the lawyer saying that before the trial began, the prosecution was all around the place saying that they were going to show videos of the people transferring the money, but they've been able to show none. And Councillor Johnson has said that the prosecution only brought Baba from LACC as its lone witness, saying that the jury should ensure that these co-defendants go home. This is a crucial trial, folks. This is a pivotal moment. He's saying that the entire case is about administrative procedures. So, folks, as the defense lawyer is making his presentation, these are what the jury needs to look at. The charge of economic sabotage, the jury must find the defendants intentionally misapplied public funds, that the transfers violated the PFM law, that their actions caused loss, risks, or misuse of public funds. So Councillor Arthur Johnson is about to define what theft of property is. He's speaking to the definition of theft of property. He has said that the entire case is about administrative procedures and administrative processes and disagreements. So the government cannot show any of these individuals withdrawing money from their account. The government did not show any of their signatures and their names withdrawing monies. The government did not show any recordings or videos of Samuel Tweah and the others removing money. He's planting reasonable doubt in the minds of jurors. He's saying that if the monies, the 1.2 something billion Liberian dollars were withdrawn, if it's in 1,000 bills, you're talking about 26 bags of money. The government cannot prove that those funds were withdrawn. Saying again, another angle that I said that the funds will be classified. Arthur Johnson is saying the same thing, that the government cannot disclose whom those funds were given to because they cannot expose the identities of operatives within the government. So based on that, the government has now proven beyond a reasonable doubt that these funds were withdrawn and personally misapplied by the defendants. Says the government cannot show any signatures, any checks with the defendant signing. So it is still happening. It is still happening in the court as we speak. Counselors are being turned away. No space in the courtroom. This is a landmark trial. Arthur Johnson is on the floor. He is making an example of the ATM, that if these co-defendants went to withdraw these monies, if they went to the banks to withdraw this money, if somebody misused your card and went to the ATM machine, all of these machines have video cameras and there will be video footages to show withdrawal. He is hammering home the point that his clients did not withdraw these monies. They did internal transfer to these agencies. The government cannot disclose the identities of whom were those who went to get those monies because of classification or classified nature. And the government cannot, the prosecution cannot hold his clients guilty for what they cannot prove. He's saying that the prosecution brought the staff from the CBL but could not bring CCTV footage to show where and who withdrew those monies. So remember, theft of property, misapplication, you don't necessarily have to prove personal enrichment. Once they cannot account for the money, that applies to misapplication and theft of property. So the defense is making this argument, and we will be bringing you all of what's unfolding live from the court. "21 minutes to 1 p.m. This final argument started at 11 a.m. Each party, each team, defense 1 hour 30 minutes, prosecution 1 hour 30 minutes. They are making their final arguments before the jurors, who will then be charged by the judge to go and deliberate and come up with their verdict. Arthur Johnson says he knows and the state knows that the money was rightly used. What's the amount in question? he says the burden still remains on the government. He said that if the prosecution wanted to prove that Moses Cooper took the money on September 21, but they could not bring the CCTV footage. So again, he's pointing to hard evidence. He's pointing to creating doubt. He's pointing to the lack of hard evidence, according to him. As a defense lawyer, all you need to do is to establish reasonable doubt on several counts. So the total amount in this case is 1.05 billion Liberian dollars and 500,000 United States dollars, moved between early September and late September of 2023 through the Ministry of Finance to the FIA, with prosecutors alleging that the transfers were unauthorized and undocumented. So these are the dates and timelines. September 5, 2023, the triggering letter. A letter from Acting Justice Minister Councillor Tweah instructed the Financial Intelligence Agency, the FIA, to receive and disburse funds on behalf of the joint security. Mid-September, the Ministry of Finance and Development Planning, MFDP, under Samuel Tweah, began transferring large sums into FIA's operational account. These transfers were allegedly done without legislative approval and outside national security clearance channels. September 21, 2023, another key transfer date. One of the three major transfer instructions bearing Tweah's signature was executed on September 21, 2023. The specific instruction involved 500,000 United States dollars. So the source of the testimony of the 1.05 billion Liberian dollars is LACC program manager Baba Mohammed Boyka. He said, the note said that this money was for joint security operations during the 2023 elections. Again, the same witness said that the real amount exceeded 500,000 United States dollars. So let's go back to the court. Arthur Johnson, the defense counsel, is still on the floor. He said that the state knows that the money was rightly used and that the prosecution, if the prosecution wanted to prove that Moses Cooper took the money on September 21 that I was earlier talking about, they could not bring the CCTV footage. He said that if they bring the footage, they will be exposing undercover agents. Again, the angle that I said that classification and these things being classified is also going to play in this case. He's pushing to the doubt and says, what's the major doubt? That the government has now brought the CCTV footage. Say the government can never bring that CCTV footage because they know they will be exposing government agents. So the government knows that the monies were used for the intended purpose, and the identification of these undercover agents are protected and classified. This is a landmark case. He is now telling the jurors that the charges, the sentences, some of these charges carry sentences of 10 years. Economic sabotage is punishable by 10 years to imprisonment, fines, restitution of the said amount. Economic sabotage includes misuse of public funds, unauthorized expenditure, and illegal transfers. Theft or misapplication of property under the penal law, that is section 15.51 and 15.56, if convicted, up to 10 years imprisonment, mandatory restitution, even if no personal benefit is proven. Misapplication of public funds is still a crime. So Arthur Johnson is telling the jurors that, look, your duty is to follow the legality. He wants the jurors to find the defendants not guilty. He says the government did not produce any hard evidence of who withdrew the money because the government knows they cannot disclose the identity of undercover government agents. He said the state also did not prove money laundering. And what is money laundering under our laws? So money laundering, the funds were moved to conceal their purpose, and the transfers were designed to avoid detection. He is now speaking to conspiracy. He says there is an agreement to carry out an unlawful act, and he says the government has been unable to prove criminal conspiracy. He is telling the jurors says because he's arguing that the monies were disbursed and used for this intended purpose, so there cannot be a charge of conspiracy. Says the government cannot show a video, the government cannot show an audio, the government cannot show anything to prove that these co-defendants conspired criminally. There's nobody to say they were part of the conspiracy. So the defense is pushing reasonable doubt. The defense is charging the jurors with these points. And as I said earlier in my notes, these are the lines that the defense will need to work. And Councillor Arthur Johnson is doing just that. Says they should return with a not guilty verdict. Says today the entire country is looking at you. After your decision today, he's telling the jurors that they will be saving the democracy of Liberia. He's saying that no matter how powerful you are, you must prove beyond reasonable doubt. He says if the jurors return with a verdict of not guilty, the whole country will celebrate. He says when the jurors return with a not guilty verdict, they will see the celebrations all across the streets. Arthur Johnson further says that the state witness came with assumptions and no evidence. He says the jurors will be saving the lives of generations by coming and returning with a not guilty verdict. It is hot in there. It is hot in there. Final arguments, legality, charging the jurors not to look at personalities, to look at evidence. So as I said earlier, folks, this is a historic case by so many facts, and some of these facts include that this case is going to make history. One, this is the first major test of the National Security Reform and Intelligence Act, the NSR Act, in a corruption case. This is the first test of the National Security Reform and Intelligence Act in a corruption case. Never before has a Liberian court been asked to decide whether National Security Authority can shield senior officials from prosecution or financial crimes. This case is also going to determine, folks, whether national security can justify moving public funds without documentation, whether the president's security powers overrides public finance laws, whether officials can claim immunity for financial decisions made under the tag security operations. And this case is going to shape how future government handles classified spendings. This is also the first time for a former finance minister to face corruption trial over internal government transfers as well. Liberia has prosecuted ministers before. We know that. Brani Samuka, the most recent example, but not a finance minister for transfers between government accounts, transfer without proof of personal enrichment based solely on procedural and accountability violations. So this expands the legal definition of economic sabotage and misuse of public funds. This is also the first corruption case in Liberia's history for the Supreme Court to intervene mid-trial on a writ of prohibition. Remember when Samuel Tweah and other co-defendants said they acted under presidential immunity? They took that to the Supreme Court. This is the first corruption case for the Supreme Court to intervene mid-trial with a writ of prohibition. So the court's involvement means that the final ruling will become a constitutional precedent in this case, and that future corruption cases involving national security will definitely cite this particular case. So this elevates this trial, just not from a financial dispute standpoint, but to a landmark constitutional one. So let's go back to the court. Arthur Johnson has said that the state witness came with assumption and no evidence. He's telling the jurors that, look, this case, if you return and you come up with a not guilty verdict, you are going to save the lives of generations. You are going to save the democracy of this republic, and that there is a lot at stake. He said to them, look, and this is the psychological part of it, not just the legal part of it, but the psychological part. You have to get into the psyche of these jurors and telling them that, look, if you come up with a not guilty verdict, you are going to save the democracy of the state, because now you're protecting the rights of these individuals. You're protecting the peace of this country. You will see people celebrating on the streets for what you've done today. You are going to go into the history books. History is going to remember you for doing all of this. Reasonable doubt is what he's planting in their minds. And then Liberia is a unanimous verdict, 12-0. Even a single juror, this might lead to a mistrial, a hung jury, and the prosecution will either, if there are jurors with doubt, go for a retrial, go for a plea, or drop the charges in its entirety. But we're far from that, because the jurors have not even retired to their deliberation room. Arthur Johnson is still on the floor. He's speaking to the PFM law, as I said. He's speaking to the classified nature. He's speaking to instances where classified payments were made. So why is this case so legally important, folks? Because this case is going to answer so many unprecedented questions. One, can national security override public finance laws? The verdict from this case is going to determine that. Can officials be convicted without proof of personal enrichment? The verdict of this case is going to determine that. Can the finance minister be criminally liable for internal government transfers? This particular case and its verdict is going to determine that. So whatever the court decides is going to become a binding precedent. Let's go back to the court. This is about 1.55 billion Liberian dollars and 500,000 United States dollars, leaving the MFDP to security accounts. No receipts, no breakdown, no final beneficiaries identified. So if the jury retires, for them to come up with a full conviction, they will need to, one, unanimously find that, one, illegal transfers were done, intentional misapplication, no lawful justification, and conspiracy proven. The consequences of full conviction: 10 to 20 years imprisonment depending on the charges, restitution, permanent disqualification from public office, historic precedent limiting national security spending. We see the distribution of t-shirts. Okay, that is personal. It's not anything relating to this case. If the jury comes out with a partial conviction, what does partial conviction mean? That is, the jury convicts on some charges and not on all of the charges. Example, the jury convicts on the misapplication and acquit on the other charges. Example, money laundering, economic sabotage. The consequences will be 5 to 10 years imprisonment, restitution, and it will set a mixed precedent. The third scenario, full acquittal: if the jury unanimously comes out with a verdict that all of these co-defendants are not guilty, the jury needs to find reasonable doubt in all of the charges. That is what to get a full acquittal. And the consequences will be the defendants will walk free. The national security discretion becomes stronger. LACC credibility will definitely be questioned, because remember, the state star witness is from the LACC. And then future corruption cases will become harder to fight, because this case, as I said earlier, will be used as a precedent, either or, whichever way the verdict goes. So let's go back into the court. So the defense lawyer says that the indictment does not stand because the indictment is based on, he's saying the pillar of the government argument is a no case. It's all about assumptions. And he says the PFM law gives him full responsibility and rights to perform any transactions. That the PFM law gives the finance minister full responsibility and rights to perform any transaction. The courtroom is definitely silent. There is a deafening silence within Criminal Court C. Arthur Johnson, the lead defense counsel, is on the floor in his final argument, an argument that has the potential to find his clients acquitted on all charges. The prosecution, with its argument, to have all of the co-defendants found guilty on all charges. He is citing precedent cases. Arthur Johnson is reading precedent cases. The jurors are listening attentively. Saying that, look, the Minister of Finance has the authority. He says that authority from the president doesn't necessarily mean that the request must be written. He says, again, as I stated in my notes, that the defense will cite an emergency, that elections are volatile times. Arthur Johnson is saying the same thing, that in an emergency, request doesn't necessarily need to be written. He can tell the president that he has the money to give or he doesn't, that the request doesn't necessarily have to be written. People are still being turned away because the court is packed to capacity. This shows how the interest in this case abounds, not just here in this courtroom that cannot take everybody, but across Liberia and the rest of the world. It says NEC didn't have that in the budget. It says there was no United States dollars. He's going to explain to the jurors what an emergency is. It says COVID-19, there was national emergency, and he's trying to cite so he's using the COVID-19 scenario that it was an emergency, and so the government also expended funds, and they did not need written approval because that was an emergency. He said there was direct request during COVID-19, but there wasn't written request, and funds were still expended. WFP was giving funds as well, and so that is also part of the precedent that it has been done before, and it's not illegal. Arthur Johnson is still on the floor. He has stated that during the COVID-19, NEC, etc., and others, monies were dispersed without being in the budget. Once there's an emergency, the funds can be dispersed. Reasonable doubt is what this defense attorney in Arthur Johnson is sowing or attempting to sow in the minds of these jurors. He says there are national security emergencies that the national security community deals with that ordinary Liberians who are not close with the authority do not know about. Doesn't make it illegal. We are still live here. Before criminal could see, my name is Diamond Slanger, here with the rest of the crew as final arguments in the Samuel Tweah and co-defendant's case is currently ongoing. We are going to bring you all of what's unfolding in the court mixed with analysis from outside of the courtroom, angles that both defense and prosecution needs to work in order to summarize their final argument before the jurors. What are the different scenarios that might play once the jury retires to deliberate in their room? Whether full acquittal, partial conviction, or full conviction? What are the punishments prescribed and what are the options thereof available? This is a serious case. So he says the president has got the authority and the president is national security. The president can call a national security meeting and the president can decide who attends those meetings, speaking to whether or not the FIA was part of the national security apparatus. to have been transferred such funds. So, folks, this is happening here live at Criminal Court C. My name is Diamond Slanger on this sunny afternoon. Liberians home and abroad, all parts of this country are listening in. There is police presence here, not very heavy police presence, but police presence enough to know that police officers are on the ground. Those entering the courtroom for the first time since we've been following this trial at this court have been frisked, checked their bags and everything checked to show how intense security measures are here. This is a precedent case. Early this morning, we saw Weazon Davis being whisked out of the court by a number of police officers for contempt of court. He's been committed to 30 days imprisonment by the judge. So he's going lucky for 30 days. Unless the judge rescinds his decision, he's going to jail for 30 days. So that is totally left to the discretion of the judge. In this case as well, we did have a judge being removed from the bench and another judge being appointed by the former Chief Justice, Sianen Yo. So this court has seen the removal of a judge and another judge being placed in charge of this case. So Judge Roosevelt Willie is in charge of this case. He is now in charge of Criminal Court A and Criminal Court C for the purpose of this case. Arthur Johnson is still on the floor. So the state is arguing that the transfers bypass the legislature, they bypass the National Security Council, they violated the Public Financial Management Act or the Public Financial Management Law, and they executed these orders outside of the National Security Reform and Intelligence Act limits. The defense position is that their clients acted under presidential authority and within the national security discretion. They also cite Article 61 and the NSR Act for immunity. Judge Willie ruled that immunity does not apply when unaccountability is required. More updates on this case. Let's see if we can get you more updates from the court. So Arthur Johnson is saying that there were security emergencies during the 2023 elections. Yes. He's arguing that there were security emergencies during the 2023 elections and that these funds were dispersed to respond to those emergencies. So we want to go back into the courtroom, and we will be going to what precedents will be set in this case when the prosecution wins and when the defense wins. What precedents will be set in this case as well. So let's see if we can get more updates from the court as Arthur Johnson is still on the floor. But if the prosecution wins, stronger anti-corruption image. If the prosecution wins, a conviction will strengthen the image of this government, of this current government, and that this government is serious about fighting corruption and misuse of public funds. It could increase public confidence in institutions such as the Liberia Anti-Corruption Commission, the LACC, the Ministry of Justice, and the Supreme Court of Liberia. It is also going to send a signal that former top officials can be held accountable regardless of political status. Also, if the prosecution lands a conviction on all charges in this case, it is going to put political pressure on the former CDC officials. A guilty verdict could politically weaken or has the potential to weaken members of the former ruling Congress for Democratic Change administration and possibly affect the opposition's public image ahead of future elections. So if the prosecution gets a conviction in this case, they are definitely going to use this, supporters of this ruling establishment, going to use this and say, look, your officials have been found guilty of corruption. So these messages are going to be used as well. It's also going to bring about international credibility and donor confidence. It has the potential, if the prosecution lands conviction in this case, that they send a message to international partners, that, and especially partners like the International Monetary Fund, the World Bank, and other agencies, that look, we are serious about fighting corruption. We are improving financial accountability and governance, and this could possibly influence foreign aid, investors' confidence, and budgetary support. Again, these are just analysis. This is about when the prosecution lands a conviction, what precedents will be set. Now we go to what legal precedents will be set if the prosecution lands a conviction. It could establish a precedent that national security, the tag national security, cannot automatically shield government officials from spending and from financial scrutiny. It's also going to set a precedent that future administrations may become more careful with off-budget or classified expenditures. Would there be possible political tension if the prosecution lands conviction in this case? Supporters of the defendants could claim that the case, as they've been claiming that the case is politically motivated, potentially increasing political tensions. Is that going to happen? Or public protests, are we going to see such? Especially if the verdict is viewed as being selective, as some supporters of these defendants have said, this is all a witch hunt. These are precedents and analysis of scenarios that might potentially happen if the prosecution lands a conviction. But what if the defense wins in this case? What precedents are going to be set? Before I move to that, let me go back into the courtroom. Arthur Johnson is on Jefferson Camo, the former National Security Advisor to President Weah. He says that Jefferson Camo letter is in no need part of the conspiracy. So let's go to the defense. If the defense wins this case, what precedent is it going to set as well? If the defense wins this case, this is going to serve as a major setback for the government's anti-corruption drive. An acquittal could damage the credibility of the government's anti-corruption campaign, especially if prosecutors fail to prove where the money went and whether the accused personally benefited. Critics and opposition detractors of this government may also accuse the government of pursuing weak or politically driven cases, as has been said by many supporters of these defendants and supporters within the opposition community, that this is all a witch hunt. It's in a vein to go after political opponents. And this could also mean, if the defense wins, a political victory for former officials, that the victory for the defense could politically strengthen former officials associated with the former president, George Weah. Supporters would likely argue that the case has proven that the former administration acted legally in handling national security operations. It is also going to bring about questions of investigative capacity if the defense wins this case. An acquittal in this case of the defendants may likely expose the weaknesses in financial investigations, evidence gathering, prosecution strategy, and coordination between anti-graft institutions. This has the potential, if the defense wins, to reduce public trust in corruption prosecutions. We go back to the courtroom. Arthur Johnson says there is nothing called a national joint security in the act, and he is still on the floor. Remember, each party has been allotted 1 hour, 30 minutes to make their final arguments or their closing arguments, if you want to call it that way. Diamond Slanger is my name. Live from outside Criminal Court C. After these arguments, once the jury moves into their jury room to deliberate, we will then go into what the possible outcomes might be from the jury deliberation. Will the former finance minister and co-defendants be going to jail today? The answer is no. They will not be taken to jail today if they are found guilty on all charges or partially by the jury. There will be a sentencing hearing by the judge. The defendants also, if they are found guilty on all charges, full conviction or partial conviction, have the right, a legal remedy that is available to them is to go to the Supreme Court of Liberia. Remember, the state cannot take an appeal, but the defendants have that legal remedy under the law to go to the Supreme Court of Liberia to pray a revision of this case. So these are the co-defendants in this case. Stanley Ford, former executive director of the Financial Intelligence Agency, the FIA. His alleged role in this case is he allegedly received and processed the transfers from the Ministry of Finance. He allegedly oversaw the FIA operations during the period when 1.05 billion Liberian dollars and 500,000 United States dollars were withdrawn. And he testifies about FIA's Unit 800 coded communication structure. Jefferson Camo, position, former National Security Advisor. His alleged role in this case, allegedly part of the joint security chain that requested or received the funds, accused of participating in unauthorized national security financing schemes, and named directly as a co-conspirator in this case as well. Councillor Tweah, former acting Minister of Justice, his alleged role in this case, authored the September 5, 2023 letter instructing the FIA to receive and disburse funds for joint security operations. The prosecution argues that his letter was used to justify illegal transfers, and he's listed as a co-defendant in this 6.2 million United States dollars trial. Sam D. Cooper, former controller, Financial Intelligence Agency, his alleged role in this case, he allegedly withdrew large sums of money using checks written in his own name, claimed he handed cash to unnamed security personnel without receipts, and his actions form a major part of the prosecution's argument about untraceable funds. He's identified in multiple reports as one of the 4 co-defendants. And the primary defendant in this case is Samuel Tweah, former Finance Minister, Republic of Liberia. He's facing charges of economic sabotage, theft of property, criminal conspiracy, money laundering. He's accused of authorizing the transfers, signing at least one major transfer instruction on September 21, 2023, and bypassing legal and security oversight mechanisms. So these are the defendants in this case. Let's go back to the courtroom. The FIA was created in 2022 and the security law was created in 2021. But the legislature said the act shall apply to all security institutions. So Arthur Johnson is pushing the angle that the FIA is part of the national security apparatus. If the FIA was established in 2022 and the National Security Reform and Intelligence Act was passed in 2021, Arthur Johnson is alluding and pushing the line that if all security agencies or all security institutions, the legislature passed that act, they shall all apply to these agencies, then the FIA is part of the national security apparatus. That's what Arthur Johnson is pushing. The defense is only to establish reasonable doubts, and Arthur Johnson is still on the floor. This is a crucial case. It is almost 1:30. This final argument started at 11 a.m. Each party allotted 1 hour 30 minutes to make their final arguments. And this case is a landmark case. Either way it goes today. Whatever the verdict will be, this case is going to have an impact, a serious reference on future cases in Liberia. Is it going to make or break this government's fight against corruption, misapplication, theft of property? Is it going to prove through this verdict that former President Tweah and his officials acted legally in handling finances, public finances, and national security spendings? A huge verdict that could, in its essence, boost the morale of the former president and his officials, or put a serious dent in their reputations as well. For the Bwaka-led government campaigning on the mantra of accountability, fighting corruption, and building public trust, Tweah and his officials have said this is all a witch hunt. These 12 jurors plus 3 standby jurors have got a serious decision to make. A decision that will not only affect Samuel Tweah and other co-defendants, but also affect the Republic of Liberia. I'm hearing the gavel being hit. Let's go back to our courtroom sources. Spoon Network. Of the panelists, our colleagues are scattered around, making sure we bring you all of what is happening. So folks are still being turned away because the courtroom is jam-packed to capacity. Arthur Johnson is on the floor. He says there is a structure of the National Security Council. Says the finance minister sits on the council as the advisor. So, according to the indictment filed by the Liberian Anti-Corruption Commission, the LACC, and the Ministry of Justice, the defendants allegedly authorized and transferred public money from the Central Bank of Liberia to accounts linked to the Financial Intelligence Agency, the FIA, claiming that the funds were intended for national security operations. Prosecutors, however, argue that the money was disbursed outside approved financial procedures and remains unaccounted for. So the charges are economic sabotage, theft of property, money laundering, criminal conspiracy, criminal facilitation, misuse of public money. So the jury will go into their deliberation room and the jurors will review the following: the prosecution's evidence, the defense arguments, witnesses' testimonies, financial documents, and legal standards. The jury must decide whether or not the prosecution proved the allegations beyond a reasonable doubt. And the verdict that the jury might return with could be guilty on all counts, not guilty on all counts, or guilty on some counts. In case they do not meet unanimously and agree on these charges, we might have a mistrial or a hung jury. So let's see if we can go back into the court. Arthur Johnson says the former Chief of Staff, Prince Johnson, lied during his testimony. So the current boss of the NSA, according to Arthur Johnson, Prince C. Johnson, former Chief of Staff of the Armed Forces of Liberia, lied on an oath in his testimony. That is a grave accusation by Councillor Arthur Johnson that the current NSA boss lied on an oath and lied in his testimony when he said he did not know whether funds were disbursed to the military, when he said he had no knowledge of funds being disbursed from this particular transaction to the military. We are still live here at the Temple of Justice. On this side is Criminal Code C. So His Honor Usman Fakai is the presiding judge. Usman Fakai is the sitting judge. He's the presiding judge of Criminal Code C, which has jurisdiction over economic and financial crimes. He is the judge who officially was assigned the Tweah case for hearing on February 26, 2026, following the Supreme Court's mandate returning the case to Criminal Code C. So, what role then did Judge Roosevelt Willie play in this case? So, Judge Roosevelt Willie, as I said, I mentioned his name in earlier commentary. His name is mentioned in earlier documents. He was the respondent judge when the rate of prohibition was filed by Tweah and others to the Supreme Court. He was not the current trial judge after the case returned from the Supreme Court. His involvement was solely procedural in this case. The writ challenged his early ruling, but he is not the presiding judge in this ongoing trial. So Usman Fakai of Criminal Code C is the current judge. He's the active trial judge. Roosevelt Willie of Criminal Code A/C on special assignments at Criminal Code C was the respondent in a writ of prohibition, and he's not the presiding judge in this trial now. The Supreme Court heard the writ, gave its ruling, and returned the case to Criminal Code C. So those are just add-ons for your information. So Arthur Johnson said Prince Johnson could not state where the law says that the Ministry of National Defense is a co-chair on the National Security Council. He said currently they are going to spend $6 million in LOFA and nobody can question them. So Arthur Johnson says the government has gone on to spend over $6 million in LOFA and nobody can question them, relating this also to an emergency as compared to what he termed was an emergency during the elections of 2023. Reasonable doubt is what Councillor Johnson is pushing. This live broadcast is being watched all across the world, all across Liberia. This is D-Day. This is not the day the Allied forces landed on the beaches of Normandy in France. This is D-Day for a landmark case purposely in the fight against corruption and graft. Friday, May 8, 2026, days after the primary defendant Samuel Tweah celebrated his birthday, will the month of May deliver good tidings to one of its celebrants, or will the month of May deliver a shocking blow to Tweah, a celebrant in the month of May? Is May going to favor Tweah, or is May going to spit out Tweah and other co-defendants? Arthur Johnson making serious accusations that the government has spent $6 million in Lofa County just on this situation of the Guinean incursion on Liberian soil, and says they have not been questioned for spending such amounts, again creating doubts. Arthur Johnson said the current NSA boss lied on an oath in his testimony, and he said the former chief of staff Prince Johnson could not state where in the law that says the Ministry of National Defense is a co-chair on the National Security Council. "26 minutes to 2 p.m. started at 11 a.m. Saw a dramatic scene where Zone Davis was bundled out, herded out. His feet couldn't even touch the ground. He was taken straight to the headquarters of the Liberia National Police on the orders of Judge Usman Fakai, presiding judge, Criminal Code C, for contempt of court, committed to 30 days. This is a precedent case. This is a landmark case. And when I say this is a landmark case, these are reasons why this case is landmark in itself. This is the first major test of the National Security Reform and Intelligence Act in a corruption case. Never before has a Liberian court been asked to decide whether National Security Authority can shield senior officials from prosecution for financial crimes. This case is also going to determine whether the tag national security can justify moving public funds without documentation, whether the president's security powers overrides public finance laws, whether officials can claim immunity for financial decisions made under the tag national security operations. And this is the first time for a former finance minister to face a full corruption trial over internal government transfers. Liberia has prosecuted ministers before, but not a finance minister for the following: 1. Transfers between government accounts without proof of personal enrichment, based solely on procedural and accountability violations. This is the first corruption case where the Supreme Court intervened mid-trial on a rate of prohibition as well. The Supreme Court's involvement, according to what I've been told by legal luminaries, means that the final ruling of this case will become constitutional precedent, and that future corruption cases involving national security will definitely cite this case as well. According to Arthur Johnson, the prosecution did not rebut their expert witness. We are still here live. The court is crowded. People are still being turned away. Arthur Johnson is still on the floor. Arthur Johnson says once the prosecution cannot show who benefited from these monies, whether their clients benefited, they cannot show any proof of withdrawal, they cannot show personal enrichment, that is reasonable doubt. They cannot show that laws were broken, they cannot show which laws were broken, they cannot bring evidence, they cannot show video evidence, they cannot show signatures, they cannot show checks, they cannot show videos of withdrawals. That is reasonable doubt. He says the prosecution cannot show any businesses that the co-defendants opened from the usage of these amounts. He says they're talking about 23 bags of rice of money. If the monies were withdrawn in 1,000 Liberian dollars banknotes, that is 23 big caliber bags. And the prosecution cannot show where these monies were taken to. They cannot show any sort of CCTV footage, any sort of images whatsoever. According to the lead defense counsel, that is reasonable doubt. He's challenging them. He says, I challenge them to show who benefited from these monies. I challenge them. He says they can never do it. The defense lawyer is at his best. Says there is no video, there is no call log, there is no bank account, there is no evidence of personal diversion, and the state could not prove none of these, any of these whatsoever. According to him, that is reasonable doubt. "21 minutes to 2 p.m. I see the beast is just packed. I see the beast is just packed right outside of the gate of the Temple of Justice. There's still the presence of police officers. There's still the presence of police officers here as well. And police officers are still that vehicle. The beast is still in my mind because of what happened to Prophet Key on the 13th of February. It was a Friday as well. The only difference here is it was Friday the 13th and this is Friday the 8th. Are we going to see these defendants taken to jail today? I've been informed by legal panelists and by research that no, they wouldn't be taken to court. They wouldn't be taken to jail, I should say, because after being found guilty, there will be a sentencing, and there will be the probation office will do the pre-sentencing procedures and all of that, and then they will come to their sentencing if they're found guilty. But if they're found not guilty, they will be acquitted of all charges and walk free. If they're found partially guilty of some of these charges, they still do have a legal remedy of going to the Supreme Court of Liberia. Remember, these co-defendants are on bond. They are out. Their bond is good. They've not violated their bond. So the beast is parked outside. That vehicle is still ingrained in my mind from that fateful Friday the 13th. In an unrelated issue, August 13 will be the release date of Prophet Key. And another individual has been sent to jail for 30 days for contempt by Judge Osman Fakai. Weazon Davis for contempt of court. So, in 30 days, starting today, you can calculate 30 days from now, unless the judge decides that he has tempered justice with mercy. We'll go back into the courtroom to bring you more updates. So after Johnson has said the state could not prove who stole the money, who stole and how much did each person take, he asked the jury that the state did not prove anything, so the jury shouldn't believe the state, and that money laundering must be dirty money, but not in this case, and saying that the jury should disregard all of what the prosecution said, because the prosecution did not state who stole what, how much was taken, which accounts were these monies diverted to, what businesses or personal enrichment did they benefit from these funds that were withdrawn allegedly, and that these jurors will be saving the democracy of Liberia if they return with a not guilty verdict on all charges. According to Councillor Johnson, there will be massive jubilations across Liberia once the jurors return with an acquittal and not guilty verdict on all charges. The state was the first to present its closing argument. He is still stressing on CCTV footage. He's still stressing on hard evidence. He's still saying if the state said and the state alleges that this individual withdrew 500,000 United States dollars and 1.55 billion Liberian dollars, which according to him will fit in 25 bag of rest. Yeah, he said if they withdrew the mile in 1,000 notes, it will fit in 25 bag of rest. And the state cannot produce any video of these people, you know, moving with the 25 bag of rest when they are here with money inside and carrying it from one place to the other and all those things. They are said to the jury, these are reasonable doubts. And he said the state cannot show anything because if the state does that, the state will be exposing undercover government operatives and it will be declassified, and the state cannot declassify information that does not warrant being shared. He said the state cannot share classified information as well. And he said the National Security Council members took an oath of secrecy, an oath to protect the national security secrets of Liberia. 1 hour, 30 minutes, allotted. And Arthur Johnson must make the most of that time. 1 hour 30 minutes to save his clients. 1 hour 30 minutes to summarize and plant reasonable doubt in the minds of these jurors. As to how long the deliberation will take, we cannot speak for that, but this is a precedent case. Live on several radio stations across the country. This shows how important this case is. Liberians of all sizes and stature and status of society listening and following across the country. Kindly let us know the quality of the audio. So please let us know the quality of the audio.
So, what folks are, whatever you're watching, this is Spoon TV, and we are coming to you live from the Temple of Justice here in Monrovia. As you may be aware, today is the final hearing involving the most fatal and the most follow right now sabotage case involving former founders, ministers, and other defendants, and the anti-Tweah, Jefferson Camus, Stanley Ford, and Moses Cooper. So former finance minister is not the only person involved in this case. He's also involved with additional 4 former government officials. So wherever you are, this is Spoon TV, and we are bringing to you live real-time update as unfold here at the Temple of Justice. So don't go away, Spoon TV. What we do, we bring you the information undiluted as it unfold. So somebody will be way in Grand Jury or Nema County asking after the hearing today, what next? After the hearing, the jurors who were selected previously before today will retire into a private room to have a consultation, some will say conference, to examine the prosecution's evidence, defense argument, witness testimonies, financial documents, legal attentions. This is not just an ordinary case. This is one of the most thorough cases right now in the country. And we are Spoon Network. What we do, we bring it to you as it unfold and as it takes. So keep following. Don't go away. Share the live so it can reach to as many people.
Many thanks to Emmanuel Phillips there. Just kindly let us know the quality of the audio. Please leave your comments on the quality of the audio. Just leave a comment, please, and your comment is going to help us improve if there is a need to improve the audio quality. We cannot go into the courtroom, folks. We cannot take our microphones into the courtroom. That is against the law. There is absolutely no recording in the courtroom. There is absolutely no photography in the courtroom, no videography in the courtroom, unless it is approved by the judge and approved at the approval of the prosecution and defense that this case will be televised live before cameras can be taken into the courtroom. So we cannot take video recorders into the courtroom, neither can we take audio devices into the courtroom, folks. So the best we can do for you is what we're doing. We'll bring you transcripts from what's happening in the court, and we will continue with our analysis as well. So please let us know the quality of the audio. Thank you there, Hila Keto, who says the audio is good. Let's see if we can go back into the courtroom and bring you more updates. So Arthur Johnson is still hammering home the point that no money was stolen because it was used for the intended purpose, and that the defense lawyer says no crimes were committed. So Arthur Johnson is wrapping up. So Councillor Johnson says there was no evidence in the entire case, and the state has been unable to prove that these jurors should not find any of the co-defendants guilty.